Shall we begin?
Yes, sir.
Okay. Good afternoon. Hi, everyone. So today we are going to be discussing a subject which is very, very close to my heart. Since in the last 27 years, I have predominantly practiced on the Writ side of the Delhi High Court and various other high courts in India. Now, I think the subject that was given is filing of writ. Am I correct, Ankit?
Yes, sir.
So we are not going to be discussing filing of a writ petition. Filing is, in any case, invariably happens. What we are going to be discussing is the essentials of a writ petition and how to get on to draft a writ petition. All right. So the whole purpose is to understand how to draft a writ petition. All right. So first of all, let's understand what is required before you actually get down to draft a writ petition. Now, before you actually get down to draft a writ petition, what you actually need. See, essentials to draft a good writ petition would be, as I think, any kind of pleading. So you must first have a knowledge of law. I'm not saying that you should know everything in law. Even I don't know everything in law, even till date. And I don't think at the time I hang my boots, I'll know everything in law. Even if I know a drop in the ocean, that'll be more than enough. But every petition that you draft has a certain, enactment encompassing it. There may be a petition under the Air Act, there may be a petition under the Essential Commodities Act, there may be a petition under, you name the act, Foreigners Act, whatever. So there can be myriads of statutes that you can have a petition. So you must know the act under which your cause of action is arising. I will deal with all these aspects of cause of action and all a little later. But you must know at least that enactment very well. You must at least, pick up the bare act and read that enactment. Then there are certain basic principles which govern the writ jurisdiction. I will deal with them in a while. Then you must know the basic principles of administrative law. That is, no order can be passed. I'm only giving an example. The situations and principles are varied. So one would be, nemo debe in causa sua. So no one shall be a judge in his own cause. Audi alteram partem. No order can be passed without hearing you at your back. So all these are principles of administrative law, which you must know, because invariably every writ petition will involve some of these, principles. The doctrine of promissory estoppel, the doctrine of, then there is a doctrine of promissory estoppel, the doctrine of res judicata, which you must know as basics of law before you actually venture into drafting of a writ petition. Because these will be required in every writ petition that you draft. Unfortunate as it may seem, but the fact is that the language of courts in India is English. So you ought to have a good command over the English language. If you know everything and if you can't express, it's of no use. Like, you enter a kitchen, you have everything all set up, all condiments, all vegetables, everything set up. But you don't know how to cook. What's the point? What's the point? There's no point. So cooking means here your ability to express what you have in your mind. So what you have in your mind, that ability to express is very essential, and that comes with your knowledge of the English language. I'm not saying that you should be, you should have English language at par with Shashi Tharoor. No, even that is not required. That kind of language is a sure no for the courts. The Shashi Tharoorian knowledge of English or English is totally not something which is required for English. Something, basic English, good English, where your verbs and tenses are correct and you are able to express yourself. So that command over the language you must have. Now, how to get onto draft a writ petition? See, I've already told you, you must have knowledge of the enactment, which encompasses a writ petition, basic principles of natural justice. Then there are certain basic principles of law that you must know. Bar of limitation, res judicata, and so on and so forth. There are various of these bars which you must. Bar of alternate remedy. You must know them, so that, and I tell you how you have to employ them. So a client walks into your office and says, I have been wronged. I have been wronged, and this is my grievance. You must first lend him an ear, hear him out, and see what is his grievance. What is he trying to say? Where does his grievance emanate? So, half the times that the clients who walk into your office don't know what they want. Don't know what they want. They're incoherent. They know something. गलत हो गया मेरे साथ, उसने गलत कर दिया, इसने गलत कर दिया, कब गलत किया, कैसे गलत किया, कुछ नहीं पता. So you must talk to them, ascertain the facts, and then you must ask them the documents. When you ask for the documents, you must arrange the documents in a chronology. So once the documents are arranged in a chronology, you will see that a picture itself emerges. And it is not difficult to arrange documents in a chronology. You have to take them, one date after the other. So the date which is the farthest comes first, and the closest at the bottom, so that you start the story. Oh, in this year, this happened, then 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 this happened. So this is how the story will emerge. You've already discussed the matter in brief with the client, and you've gone through the documents. Now, your task as a lawyer is to find out if the client is concealing anything. That you can make out. Once you have the documents and you see that there is a document which refers, there is a document and there is another document, subsequent document. The subsequent document refers to some document prior to it, but the document which is given you, which is supposed to be there, is not there. So there is a missing link. Then you ask the client, where is this missing link? You ask the client, where is this missing link? And the client will tell you that, hai ji, nahi hai ji, ye hai. You have to be very, very clear. You have to tell the client, if you don't get me this document, I'm not touching your petition. Because the courts are very, very serious and very, very strict about concealment. Concealment. And somewhere the concealment, is attributed to the lawyer. The client will say, ji, maine to bataya tha, client lawyers ko, unhone nahi lagaya. So it's the lawyer's reputation also which is at stake. So you must know that the client is not concealing anything from you. You must get everything out of the client. All his facts should be there in black and white before you. Once you have the facts clearly before you, then what you must do is this. Once you've seen the facts, once you've ascertained the facts, once you've seen that the client is not hiding anything and a clear picture emerges, you must see whether there is actually a cause of action which is emerging. A cause of action which is emerging. Is there a reason to go to court at all? Is there a reason to go to court at all now or at all? Now there are people who file a writ petition in anticipation. The writ petition is dismissed as being premature. So the government has announced a policy and says, okay, we are going to be distributing something or going to be doing something, and somebody goes and files a writ petition. The government has not even implemented it. And you go and file it. The court will say it's premature. There can be myriad of situations where a writ petition is premature. So you have to first of all see whether the time is ripe to file a writ petition for your particular client. Then you have to also see if there is any prior proceeding. The client has ventured into litigation previously, and the client has, suffered an adverse order or something. So in that situation, you must ask him for the record of that proceeding, because there can be a bar of res judicata. The client has already suffered an order and all doors are closed for him, and he still wants to, through a different lawyer, through a different set of people, through a different, wants to explore again. That has to be issued. You can't permit that. As a lawyer, you can't permit that to happen at all. So you will have to see whether the time is right, whether he has already suffered any adverse order in those proceedings elsewhere, and whether a writ petition is actually made out. Then you must also see whether there is a bar of alternate remedy. Now that bar is a very, very strong. See, writ jurisdiction does not have, Article 226 security does not have all these restrictions. These are self-imposed restrictions by the court, right? So, bar of alternate remedy. If a particular statute says that if there is a grievance, if there is an order passed, or if there is a grievance, you must approach a particular tribunal, then you must approach that tribunal. Then you must approach that tribunal. There is no reason for you not to approach the tribunal, unless and until you are faced with a situation like there is no member in that tribunal. The tribunal is not holding its hearings, or the person who was the incumbent has retired or has demitted office, and the new incumbent or the new person who has to take over has not taken over. So there can be various situations where you can approach the High Court and say, look, my remedy lies there, I know that, but I'm approaching the High Court because I can't go to the tribunal and I can't be left remediless. So you have to be very clear whether there is a bar of alternate remedy operating. And if there is a bar of alternate remedy operating, then you have to advise the client that please don't venture into writ petition. You exploit you take your recourse to an alternate remedy. I think having touched this, let's see who can file a writ petition. So you all know that writ petition can be filed under Article 226 and 32 of the Constitution. Both have provision for writs. Both are constitutional courts. So the power of issuing prerogative writs vests only in the constitutional courts. So Article 226 lies with the High Court and 32 lies with the Supreme Court. There is a difference, fundamental difference. That you can approach the Supreme Court under Article 32 if there is a violation of a fundamental right. Whereas you can approach the High Court if there is violation of a legal right or failure to perform a legal duty. Public duty, legal public duty. If there's a violation of a legal right, I have a right. I have a right. I have a right to get an Aadhaar. Guy I go to, he says, I won't give you Aadhaar because I don't like your face. My legal right is infringed. You can go to court and say that he is not, my legal right is infringed. Fundamental right also, under Article 32, you can approach the Supreme Court when your fundamental right is infringed. So that's the basic difference. Now, since I am dealing with 226, legal right, fundamental right, I must tell you something. Traditionally, we've all said by whom, I've just said by whom a writ petition can be filed. Now, coming to the first aspect, going on from the first aspect to the second, against whom a writ can be filed. A writ can be filed, traditionally it was said, can be filed against anyone, who was an instrumentality of state, government, public authority under Article 12, or other authority under Article 12 of the Constitution. Over the years, this concept has been watered down, right? This concept has been watered down. And in Board for Control of Cricket in India versus Association of Bihar, Cricket Association of Cricket Bihar, the court said, look, even BCCI, which is just a society, Board for Control of Cricket in India, is just a society registered under the Tamil Nadu Act, Societies Registration Act, will be amenable to writ jurisdiction. And the court had its reasons to say that. The court said because BCCI controls the game of cricket in India, it selects players, sends them abroad, it selects coaches, everything. It's a huge network it has. And then lots of hopes and aspirations of a large number of people is pinned on, cricketers, coaches, everybody is pinned on the BCCI. So they said that BCCI will be amenable to jurisdiction. There is a very interesting paragraph towards the end, if I may just read that. The court said, such is the passion for game in this country that cricketers are seen as icons by youngsters, middle-aged and the old alike. Any organization or entity that has such pervasive control over the game and its affairs, and such powers can make dreams end up in smoke or come true, cannot be said to be undertaking any private activity. So this was the reasoning that the court gave or holding that the BCCI is performing a public duty. Therefore, it's amenable to writ jurisdiction. So traveling from traveling from that I have a legal right which has been infringed to the fact that the other side has a public duty in the nature of a public duty. We have traveled very far. So when my legal right is infringed or a public duty is owed to me by somebody, that duty is not fulfilled, I can approach under Article 226. Whereas if my fundamental right is infringed, I can approach the Supreme Court. Please remember, a foreigner also has a right to invoke Article 226 and 32 as well. Habeas corpus can be filed by anyone. So once you know against whom you have to file the writ, you start mulling over the facts. Put the facts in order. As I said, once you make a chronology of events, the facts emerge themselves. Then you have to be very clear about two things: that there is no bar, which I said, bar of alternate remedy, bar of res judicata, and The court you're going to approach, the High Court you are going to approach, like you're going to approach the Delhi High Court, whether the cause of action has arisen within the territories in which the Delhi High Court exercises jurisdiction. So only then you can approach the Delhi High Court. So you have to be clear about the territorial jurisdiction of the court. So if the cause of action has arisen in Delhi, you can't approach the courts in Odisha, West Bengal, wherever Calcutta, or Writ. Because the cause of action has arisen in Delhi, the courts in Delhi only will have the jurisdiction to, will have the jurisdiction. Now, the other aspect, which is very crucial, there should be no, limitation per se does not apply to writs. So it does not say, the limitation statute does not say that if a cause of action has arisen, that if the cause of action has arisen, निकल गया क्या?
Yes, sir.
I'm there?
Yes,
Okay.
sir.
I don't know what happened.
You are audible, sir. Your video stopped, but you are audible.
Just a minute. I don't know. I did something. So.
Yes, that's all right.
Okay. So what I was saying was.
Yes.
There is no limitation per se, right?
Yes, sir.
Am I visible?
Yes, sir. You are visible and audible.
Okay. But, okay. So, but the courts say that, look, you must approach the court well within time, right? I'll give you an example. Normally, for normal suits, the time limit is 3 years, right? 3 years. 3 years the time limit to file a civil suit. Normally, I mean, I'm not saying, for predominant number of suits, it's 3 years. So courts say, all right, if you are coming within the period of limitation as generally prescribed, that is 3 years, it is all right. The courts will entertain. But there are situations where the courts say, no, your possession was being taken a week ago. You knew that the demolition is going to be happening. You've come now. After a week, 10 days, 15 days, we are not going to entertain your petition. So the courts have refused, declined to entertain a petition, even where, it's within a month. Writ petition has been filed within a month of the cause of action arising, 2 months, 1 week. There are instances galore. Please read them. You will find undue delay. There should be no undue delay. The concept of writ jurisdiction is that there should be no undue delay. We are not going by any concept of limitation. All right. So there should be no undue delay. And once you're sure about it, that there is no undue delay, the court has territorial jurisdiction, there is no bar of alternate remedy, there is no bar of res judicata. Once you're sure about these bars operating, basic bars operating, then you take up this client's matter, start drafting his writ petition. As I said, when I began today, I said, you should know what the client wants. The client walks in, सब कुछ चला गया, सब कुछ हो गया, ये हो गया, वो हो गया, अरे हुआ क्या? Where is the cause? Where is the cause? So you must determine what is the cause of action in his favor. Where has the cause of action arisen? कुछ हुआ भी है, which should prompt you to go to the court and seek some relief. Now, seeking the relief, I have to touch upon the various kinds of, writs. Firstly, please understand that the technicalities of writs, of the writs, as they've been in the United Kingdom, do not apply to India. So the technicalities of a writ jurisdiction are not applicable to India. But predominantly, we have four kinds of writs. One is the writ of habeas corpus, produce the body. So the most frequent cases that are coming up these days in court are, parents are against a marriage because the daughter wants to get married out of caste, and there is an intercaste marriage which is looked down upon in a lot of sections of the society. So they say no marriage and they elope. And then they elope. So somebody who's worried about them actually, and who is fearing that, I'm only giving you an example, is fearing that both the boy and the girl will be killed by either one of the sides, files a writ of habeas corpus saying produce the body of the person to court. The court directs the police to get their people to court. The boy and the girl are produced. The court asks them whether they are majors and they're able to live together, and then they counsel them and send them together home. So habeas corpus is produce the body. The other kind of writ, which is the most common, is writ of mandamus. Writ of mandamus is a writ to do something or to forbear from doing something. It basically means that to do something or to forbear from doing something. So if an authority owes a public duty to me, like I said, if I have a right to get a PAN card or an Aadhaar card, and the concerned authority says, no, I can't give you because I don't like your face. So I will go to the court and say, look, I need an Aadhaar card. That's my right to have an Aadhaar card. They owe a duty to me to issue an Aadhaar card. So please issue an Aadhaar card to me. Direct them to issue an Aadhaar card. The court is not going to issue itself. The court will direct them to issue an Aadhaar card. So that's a mandamus. Or the mandamus is, the situations in which a mandamus can be issued are myriad. You have like the ridge in Delhi. Supposing the ridge is not being cleaned by the concerned authority, there is dumping of Malba. The court can issue a mandamus to the authority that you remove the Malba, you remove the waste and clear the ridge. That can be a mandamus, form of mandamus. The other thing is writ of prohibition. Prohibition, as the name suggests, is to stop the authority from doing something. If the authority is going to do something which is illegal, or where the authority is venturing into doing something without following the due process of law, then you file a petition saying prohibit the authority from doing it. Right? Supposing an authority wants to make a road. One fine day, somebody gets up and says, oh, let me make a road through Nehru Park. Divide the Nehru Park in two parts. Let me have the road. There is a process in law which you have to fulfill. It's not your ipse dixie that one fine morning you get up and say, oh, well, the sun is shining bright. It's a good day, so let me divide Nehru Park into two. No, there is a process of law that you have to go through. It's not your ipse dixie that you can do that. So you will go to the court and say, issue a writ of prohibition, prohibiting the authority from, executing its fanciful idea. I'm giving you a very absurd example. Giving a very, very absurd example. It's not going to happen. I just hope it's not going to happen in my lifetime. It doesn't happen in my lifetime. So you will get to the court and say, issue a writ of prohibition. And the last kind of writ is quo warranto. When somebody, who usurps an office, who is not entitled to an office, somebody who, by virtue of, by reason of his education, experience, whatever, is not entitled to hold an office, and he goes on to hold an office, surpassing others, surpassing others who are entitled to hold that office. So you will go and seek a writ of quo warranto. Remove that person from that office. Remove that person from that office. And I'm going to be, holding that office. So it is this. So we've discussed. So the kind of writs will determine what kind of, you'll have to frame then what kind of writ you're going to seek. But I must tell you, the best thing is not to go into these technicalities. Whenever I had been drafting writs, I would have always said a writ in the nature of mandamus, a writ in the nature of quo warranto, because I am aware that a writ, technical writ does not lie in India, right? So I would say a writ in the nature of mandamus, a writ in the nature of prohibition, a writ in the nature of quo warranto, directing and commanding so and so to do so and so or not to do so and so. So that's what we also say, writ in the nature of so and so. Now, while I'm here, I want to tell you something which I have been, telling people, my students everywhere. There's something very interesting. So various applications are filed when you file a writ petition. You file an application for injunction. You file an application for exemption from filing certified copies. You file an exemption, from filing typed copies because you're running short of time and you can't file typed copies of the annexures to the petition. I see most of the people, what they do is they say application under section 151 of the Code of Civil Procedure. There were some judges in the past who took serious offense to it. When you are approaching the court under a constitutional remedy, where is the question of getting CPC into it? CPC will not enter a constitutional remedy. So a constitutional remedy, when you file an application, since we are looking at drafting of a writ petition, with the writ petition go various applications, injunction, stay, whatever, exemption. An application which accompanies a writ petition always has to be under Article 226 of the Constitution. You may say an application under Article 226 of the Constitution on the analogy of Order 39, Rules 1 and 2, read with Section 151 of the Code of Civil Procedure, if you are going for an application for injunction. But you will move that application under 226. See, 99 times it will pass. Nobody will bother. People are not bothered. People don't know. People don't bother. But that's something wrong. If there's something wrong, you must not indulge in something which is wrong, and something which is not perpetuate something which is wrong. You must always say writ petition under Article 226, application under Article 226 of the Constitution. For the application, you can say application under 226 on the analogy of 151, on the analogy of Order 26, Rule 9. Order 26, Rule 9 is when you want the court to appoint a local commissioner to go and inspect something. So that's what you do. Now, coming to the reliefs. I've already said what kind of relief and what you will ask. There is something which is very important, which is that now that we've come, which I have missed, when I was saying limitation. Limitation. There's no limitation. There is no bar. It's only the court will look at that you have come to the court expeditiously. One thing which you as practitioners, when you practice, will realize, some of these clients have a tendency, especially in the realm of service law. They'll send a representation. I have been superseded. My seniority has been wrongly fixed. And they will keep making that representation, one representation every month for years together. The law with regard to that is repeated representations will not extend the period of limitation unless and until such a representation is statutorily provided. So where I have a grievance and it says if you have to remedy your grievance, you have a remedy. In the first instance, you make a statutory representation. I make that statutory representation, and the authority does not decide that representation. And I keep making those representations one after the other. That please decide my first representation. Please decide my first representation. In that case, the authority is at fault, and these repeated representations will actually extend the period of limitation. They will actually extend the period of limitation. There's no limitation. I mean, they will help you to tide over the bar of delay and latches. Unlike suits, civil suits, where the bar is of limitation, that the suit is barred by limitation. Here, a writ petition is barred by delay and latches. A writ petition. So what you have to be very careful that that writ petition is not barred by delay and latches. Now, Ankit, when you spoke to me, you asked me about, you started with a PIL. And I said, not a PIL, writ would be a better. The reason is that in a PIL, the high courts have prescribed their formats. So what is basically to be followed is the particular format which a particular high court has prescribed where you're filing the PIL. So there's no rocket science in it. But one thing which you have to know, two things which you must know, that a PIL is a public law remedy. And a PIL can be filed only where there is a larger public interest to be subserved. In fact, where it is my individual interest, I cannot file a public interest litigation. There I have to go under the writ remedy. But where I am wanting to file a writ petition or a petition in the nature of a writ petition, the course is to I distinguish the two, that whether I can file a writ or a PIL. So a PIL in fact is an exception to the rule of locus standi. Locus standi. कोर्ट कहता है भाई तुम्हारे को परेशानी है ना, जिसको परेशानी है वो कोर्ट आएगा. तुम बेफालतू में you are not a monger. You are not a monger that you will keep taking up issues and publicity hungry. That आप आओगे हर चीज में. But where there is a genuine cause for the public at large, even the court will even entertain a PIL on the basis of a newspaper report. On the basis of a newspaper, the court will entertain a PIL. Locus standi is not applicable. In fact, locus standi is an exception to PIL, right? Otherwise, court will say, what is your locus to file a writ petition? ठीक है? अरे अंकित का वो नहीं मिला, पैन कार्ड नहीं दिया इनकम टैक्स अथॉरिटी ने, शालिनी क्यों आ गई भाई? What? She is not his guardian, right? He's a major, he'll come to court himself. So locus is relevant for writ jurisdiction, but locus is completely diluted in the case of a PIL. So it's an exception. Then I think I have touched upon basically everything that draftsmen would require. Yeah, देखो, at the end of the day, I have always said the drafting of a suit or drafting of a writ petition, it's like painting on a canvas. You know, you have to have a vision, you have to have an idea, and you have to take it in the flow, right? You have to take it in the flow. तभी picture बनेगी, right? तभी picture बन सकती है. अगर बॉक्सेस होंगे कि यहां से ये उठाया, वहां से उठाया, ये उठाया, वो उठाया, तो पिक्चर नहीं बन सकती. पिक्चर तो तब बनती है जब एवरीथिंग कम्स इन अ फ्लो, राइट? So that is very important to know what is, you must have an idea where, what is, so your idea is, ultimate मेरा गोल क्या है मैं रिट फाइल करने के लिए, मुझे रिलीफ क्या चाहिए, मुझे क्या रिलीफ चाहिए, किसके लिए चाहिए, किससे चाहिए, किसके लिए चाहिए, for whom do I want the relief, from whom I want the relief, what is the relief that I want, and the connecting part are your facts. You know, the connecting part are your facts. कि मुझे इसके लिए रिलीफ, इससे रिलीफ, ये रिलीफ ऐसे मिलेगा जब मैं ये पूरी कहानी बनाऊंगा. It's a story that you're going to tell the court. Don't have to be repetitive. Don't have to use a flowery language, but English should be good, simple. One thought merging with the other. You know, अब पेंटिंग अच्छी कौन सी होती है? Not that I'm a painter, but वही होती है ना जिसमें हर पेंट्स जो होते हैं बड़े beautifully merge करते हैं एक दूसरे में. You know, they blend into each other. Where the strokes are you know, are unsystematic. That's not a painting. Same thing applies to a writ petition, right? So you have to, you know, be very careful. The other thing which I was wanting to say, and I'm trying to just think what I was wanting to tell you guys with regard to writ jurisdiction. I think, Ankit, I think I have touched mainly what I wanted to say, spoken for.
Yes, sir.
45 minutes. I think I can take questions now for another 15 minutes.
Okay,
if somebody
sir.
has a question.
So I have received some questions and I have a few of my own as well. Let's
Please tell
take it
me.
this way that I'll post them to you orally and you can answer them.
Okay.
Could you just shed some lights on the best practices or say habits while drafting a document, while drafting a writ petition? See, a lot of writ petitions get filed in the Supreme Court or a High Court, but only a few of them gets admitted. So, is there anything we can do to ensure?
Yeah, no, admission or relief is not in your hands. You know, it's not in the hands of a lawyer. A lawyer is simply the link between the court and the client. The lawyer has to present in the best possible way the case of the client. One thing flows from what you've asked, Ankit. A lot of times, what happens is people go to court. Shabby writ petition बना दी, कुछ नहीं लिखा, जाके कोर्ट में बोल रहे हैं, बहुत कुछ बोल रहे हैं. The court says, where have you said so? Which page? Where have you said so in the writ petition? And then the lawyer gets, you know, has cold feet. पता ही नहीं, लिखा ही नहीं है. You know, he has not written. So whatever you want to convey to the court must be there in your petition. अभी एक और problem है. See, the courts are overburdened with matters. They work very hard. The judges, you know, you don't know probably, the judges work till 10 o'clock in the office, in the High Court. They sit in the chambers. And then they read the files, they read the orders, they do so many things. You know? They do so many things. So,
Exactly.
judgments aane mein, or there is a time lag between the arguments are heard in court and the judgments are delivered. So what becomes relevant is what you've written in the petition, how you supported the case in the case, how you supported your petition with the case law. So agar मैंने बहस किया कुछ, it's fresh in the mind of the court, you know, court will say, all right, ये बहस किया था, ये but अगर 2 महीने बाद जजमेंट लिखवाना शुरू किया है कोर्ट ने, जज ने, आधी चीजें तो भूल चुके होंगे, but when he will pick up the petition and say, हाँ ये बहस की थी, इस तरह से बहस की थी, ये लिखा है, he will remember immediately, right? So it's very important to say whatever you want to say in the petition. Take time in drafting the writ petition. The client की एक tendency होती है सोचने की, and never come under that pressure of a client. वो सोचता है यार, the lawyer is, you know, like a dispensing machine. ऊपर से coin डाला और lawyer ने dispense कर दी petition. ऐसे नहीं होता है. Lawyer का दिमाग लगता है, time लगता है. So I have always told the clients, I'm not a dispensing machine. कि आपने जी पैसे दे दिए काम करने के और अगले दिन आपको petition मिल गई. Petition बनाने में वक्त लगेगा. अगर आपको चाहिए काम ढंग का. So you have to do that. One thing, Ankita, from what you are saying, there's one thing, yes. इसका जो तुमने सवाल किया, उसका एक और भी angle है. And that's very important, and I'm thankful. मेरे ध्यान में नहीं था. See, in the High Court and the Supreme Court, with the writ petition, what is filed is a list of dates and synopsis. There's a date, what happened on that date. It comes in a chronology and brief synopsis of the matter. कि तुम्हारा case क्या है? What is it that you are asking? Very brief. 1 page या 2 page में. List of dates also very short and crisp. You know, I have seen people who have 13 pages of list of dates, filing an application to the court for permitting to file an exhaustive list of dates. Hey, court उसमें से अच्छा तो petition ही नहीं पढ़ लेंगे. Instead of reading a list of dates for 13 pages, the court will be happy to read the petition itself. So that list of dates and the synopsis will be something which the judge will definitely read when he comes to court for the first time to hear your matter. As the notice is going to be issued or dismissed, largely will depend how crisp and how nice are your, apart from various other things, are your list of dates and synopsis.
Okay, sir. There's a question by Gitanjali Kapoor. She says, if I want to quash a district commission order under writ by way of a certiorari, then who will be the respondent? Do I make the lower court itself a party?
No, not any. No, you don't. Firstly, let me tell you, how will you file a writ petition to quash for seeking a writ of certiorari against an order of the district commission? Now it's called the district commission. How can you do that? You have to go to the state commission, then to the national commission in revision. You can't go. So the writ does not lie. You're bypassing the remedy of a statutory first. Secondly, there was a second part of the question. How will I file the writ? Who will be the respondent? No, earlier this used to happen. I don't remember the judgment, Supreme Court, which says no, the tribunal whose order you need to be, whose order you want to be quashed, need not be made a party. So it used to happen. The CIC, the Chief Information, the Central Information Commission. Central Information Commission passes an order against the central government to disclose certain information. The central government goes to the High Court. It would make the CIC or the Information Commissioner a party earlier. Not anymore. After this judgment, no. You don't have to make the... I'm saying otherwise, but I think Gitanjali's question is slightly wrong, that a writ will not lie against an order of the district forum. You have to take the legal recourse in terms of the statute go to the state commission. But wherever, in other circumstances, wherever you are asking for a writ of certiorari, the tribunal whose order is impugned need not be made a party. Next.
Yes, sir. Okay, this is a sort of a hypothetical question. See, am I audible, sir?
Yes, yes, you are, Ankit. Please tell me. Yes, yes, please tell me.
Okay. So we know that Justice H.R. Khanna was not made the Chief Justice of Chief Justice. Okay, I
Of the
think they have
Supreme Court, he was
mistaken the
superseded
name,
during
but we know that
emergency.
A.N.
Yes.
Justice A.N. Ray was made. Yes, yes, precisely, sir. So the question is that would a writ of quo warranto be filed in that case?
No, it cannot be filed. See, the concept of seniority in succeeding to the seat of the Chief Justice. These are matters of practice. The outgoing Chief Justice recommends the name of the next Chief Justice, the incumbent Chief Justice. And the government of the day had a lot of power in those days. Emergency was there. And so it was a different regime, legal regime altogether. In any case, what you're talking about, a writ of quo warranto wouldn't have lay. Probably you don't know, 1975, when the emergency was imposed, the fundamental rights were suspended. So fundamental rights, all fundamental rights were suspended. Article 226 is a fundamental right to approach the court under Article 226 is a fundamental right. So you couldn't approach the court under 226 or 32. You couldn't, because the right was suspended during emergency.
Okay, sir. Those are the questions. If you have any last comment.
No, I'm no comment. I just wish you all very good luck and hope to see you all at the bar and prospering at the bar. I'm sure, uh, you know, uh, make good use of this lockdown time, make good use of this time when you are having classes through PC, video conferencing, through remote distancing. Make good use of them. See, I can tell you, जो ये student life है या initial years of profession है, उसमें जो आप पढ़ते हो वो आपके साथ जिंदगी भर चलता है. मैं रोज सोचता हूँ कि नया SCC आया है, नया वॉल्यूम आया है किसी लॉ जर्नल का, मैं उसको लेके भी जाता हूँ अपने साथ और वो ऐसे के ऐसा वापसी आ जाता है. Don't get time to read. I try to be abreast. Fortunately now बहुत सारी चीजें हैं जो WhatsApp ग्रुप में आ जाता है, बहुत सारी चीजें पता लग जाती है. So one is abreast with law that way. But वो पढ़ाई लिखाई कहीं बहुत पीछे छूट जाती है जो आप प्रोफेशन में आ जाते हैं. तो मेरी आपसे बस यही रिक्वेस्ट है, because you are the ones who are going to be taking the baton of this future of this profession. Please पढ़ें, अच्छी तरह पढ़ें. That's all.
Thank you for the wonderful session, sir.
Thank you, Ankit. If anyone has any question, you can always, forward it to me on WhatsApp or whatever. I try and answer it. Yeah? All right. Take care, Ankit.